Have you ever gone to court because you felt a company treated you unfairly?
No. Too much effort, too expensive, and I really don't know my way around courts. And I'd probably be a bit scared too.
Exactly. And that is exactly what could change through tools like ChatGPT.
Yeah, totally. It's a massive shift.
We are diving into the files of a truly bizarre legal battle today. And I mean bizarre.
Oh, it is. It's a classic David versus Goliath setup. Right.
On one side, we have a simple package of baby semolina powder, €2.49.
Yep, $2.49.
And on the other side, you have the highly armed legal department of a massive billion-euro retail corporation.
And caught in the middle is just a regular consumer who, well, she decided to turn the tables on them.
Exactly. So our mission for this deep dive is to unpack this. We're not just looking at a tiny refund dispute.
No, not at all.
We are illuminating a fundamental shift in power dynamics. We're talking about how access to the legal system is being democratized by AI.
I mean, think about it. Usually the barrier to entry is just too high for regular people.
Exactly. Like, imagine you are a university student,
Gosh,
right? And the university rejects your appeal against an obviously unfair grade using some, standard boilerplate text.
Or you're a patient trying to take on the lawyers of a massive hospital clinic.
Yeah, or you're building a house, and the contractor's expert gives you this completely useless but insanely expensive report.
In the past, in all these scenarios, it was the law of the strongest, or really the law of the deepest pockets.
Right, you just felt powerless.
And that powerlessness comes from this massive information asymmetry.
Oh, totally. The corporation has the lawyers, the processes, the endless resources.
And the individual has, at best, a legal insurance policy with a deductible that's way higher than the actual amount in dispute.
It's just not worth it. But today's case study shows how structured logic and modern legal tech approaches, especially AI, can break that asymmetry wide open.
We are going to look at how a human corporate lawyer actually starts hallucinating facts during the trial.
Which is wild, by the way. I can't wait to get to that part.
Me too. And we'll see how a supposedly untouchable official lab report gets completely dismantled by just cold, machine-like logic.
And we even have a satirical cartoon to talk about at the end.
Oh yeah, the Esselman cartoon. It's brilliant.
All of this is based on original court rulings, the statement of claims, and the actual letters sent back and forth.
It's a gold mine of source material.
So let's jump right into the inciting incident. We're going back to August 15th, 2025.
Right, a very normal summer day.
Our protagonist, who we'll just call the consumer or the plaintiff throughout this deep dive, walks into a branch of the retail giant Rossmann.
Her goal is completely unspectacular. She's just buying baby food.
Exactly. She picks up a 250-gram package of El Natura baby semolina.
For €2.49.
She pays, leaves the checkout area, and opens the package right there near the store.
And this is where the crucial detail comes in.
Right. Immediately upon opening it, she notices a really strong, rancid, musty smell.
Now, we need to be very precise here.
Yeah.
This is from her perspective.
Yes, exactly. According to her representation of the events, she perceived this rancid smell right away.
And context is everything here. We aren't talking about a bag of chips that might be a little stale.
Right, this is baby food.
Exactly. From an evolutionary biology standpoint, parents are incredibly sensitive to sensory anomalies when it comes to infant food.
Oh, I mean, you don't mess around with what you feed a baby.
You really don't. The plaintiff actually points this out later in the court files.
She does, yeah.
She rightly emphasizes that with toddler products, there is an absolute zero-tolerance policy.
If there's even the slightest suspicion that the food might be bad, no rational person is going to mix that powder with water and feed it to their child.
The protective instinct just takes over immediately.
So acting on that instinct, she walks right back to the checkout with the open package.
She explains what she smelled and just asks for a refund.
A completely normal, everyday retail transaction, you'd think.
You would think so, yeah.
But instead of just handing her the €2.49, the store staff completely dig their heels in.
Their justification was literally just, well, the package is already open.
Okay, wait, I have to play devil's advocate here for a second.
Go for it.
Don't the employees have a valid point? I mean, retail stores can't just systematically take back open food items because a customer says their nose itches.
I get that. From a pure inventory management perspective, it makes sense.
Right. Where would we end up?
But that completely ignores the mechanics of consumer law and the nature of this specific product.
How so?
Well, we are dealing with an opaque, sealed package. You can't see or smell the powder through it.
Oh, right. It's the classic retail catch-22.
Exactly. How is a consumer supposed to know if a sealed powder smells rancid without breaking the seal?
They literally can't. It's impossible.
So from a legal standpoint, this is about the suspicion of a material defect at the moment the risk transfers to the buyer.
Meaning the moment she bought it.
Right. And the customer has the right to a replacement, or if that fails, to back out of the purchase contract.
So the argument of, oh, the package is open doesn't actually override statutory warranty rights.
Not at all.
Yeah.
If you buy a brand new car and the engine explodes on the drive home, the dealer doesn't say, well, you already opened the door and sat in it, so no returns.
That is a great analogy. So the exact same logic applies to baby food.
Exactly. But anyway, a discussion breaks out at the register.
And the staff are being really stubborn, right? They try to brush her off.
Yeah. They want to send her to a central customer service hotline immediately.
But she doesn't back down. She insists on her rights.
And eventually, they cave a little bit. They give her a replacement package of the exact same product.
But then the consumer does something really methodical.
She sure does. She opens this second package right there, right in front of the staff.
And boom, according to her, the exact same rancid smell hits her again.
So at this point, she demands her money back once and for all.
Legally speaking, the reversal of the purchase contract.
Right. And what follows is just an absurd escalation.
Because the staff refuse the refund again.
They do. And then they pull out an argument that the plaintiff absolutely tears apart later in her legal briefs.
Oh, I love this part. Tell them what the staff did.
The employees actually smell the package themselves and just declare that the odor is, quote, completely normal.
Just normal.
Yeah. But picture this scenario. You are standing inside a drugstore.
Okay, I'm picturing it.
The air is basically an olfactory assault.
Yeah.
You've got hundreds of synthetic fragrances mixing together.
Oh, yeah, the laundry detergent aisle, the shower gels, perfumes, room sprays.
Exactly. Your sense of smell is massively compromised in that environment.
And the plaintiff actually brings this up in the court documents, right?
She does. She asks this brilliant rhetorical question.
What was it?
She questions whether these specific drugstore employees have ever actually smelled fresh baby semolina porridge in their entire lives.
Let alone prepared it.
Right. Like, what sensory expertise do they have to certify that the smell of infant formula is normal?
That is such a sharp point. But anyway, they reject her again.
They do. They basically tell her to call the hotline and more or less show her the door.
So we really need to talk about the microeconomics of customer complaints here.
It's fascinating, isn't it?
It is. Why does staff act like this? Why alienate a customer over €2.49?
Because it's a systemic strategy. Corporate structures are designed to create friction.
Friction, right.
That referral to the hotline,
Yeah.
that's a calculated barrier.
Because they know the average consumer is going to weigh the costs and benefits and just give up.
Exactly. The opportunity cost of waiting on hold for 30 minutes just to get €2 back, it's just too high for most people.
So the goal is for the complaint to just vanish into the corporate bureaucracy.
It's their standard defense mechanism for petty claims.
Friction is such a perfect word for it. They build this obstacle course.
But Rossmann totally underestimated this specific consumer.
They really did, because she does not vanish into the hotline black hole.
Not even close. She gets incredibly systematic.
And she has some serious backing. She's supported by Professor Dr. Beel and his Intelligent Systems Department.
Right, and they use tools that basically neutralize that corporate friction.
So on the exact same day, August 15th, she goes straight to the health department.
The veterinarians, yeah.
She reports the batch to have it tested, to protect other babies.
Which is the responsible thing to do.
But then she takes it a step further. She goes to the local court in Hagen.
Ja, amtsgericht.
And she applies for an official Mahnbescheid, a court order for payment.
Over €2.49.
Let's unpack that because it's a huge move. What exactly is a Mahnbescheid?
So the judicial dunning process, the Mahnverfahren, is a tool in Germany meant to enforce undisputed financial claims quickly.
Without needing a long trial.
Right. But traditionally, it was this nightmare of paperwork. You had to know exactly which box to check on these complex forms.
I can imagine most people would just give up right there.
Exactly. But now it's digital. And this is where LegalTech comes in. If you know how to use structured systems or AI models, you can feed all the facts, the claim, the interest, and the fees perfectly into this system.
So the technology completely removes the fear of the bureaucracy.
Exactly. The court checks the form, to make sure it's filled out correctly, but they don't check the facts.
Wait, they don't check if the baby food was actually rancid?
Not at this stage, no. They just issue an official, court-mandated demand for payment and send it to the debtor.
Which in this case is Rossmann.
Right.
But she doesn't stop there. A week later, on August 22nd, she fires off another document.
A highly formal, out-of-court demand letter.
And she sends it straight to the Rossmann corporate headquarters in Bergwedel.
And this letter is a masterpiece of precision.
She lays out the facts flawlessly. She explicitly names witnesses, including Professor Beel and her mother,
Who can testify about the incident or the smell.
and she's not just asking for $2.49 anymore, is she?
No, the stakes have gone up. With dunning fees, expenses, and postage, the claim is now at 48.09 euros.
And she gives them a hard 7-day deadline.
The situation has officially escalated.
So how does the mighty corporate legal fortress respond to this incredibly precise letter?
They completely ignore it.
Wait, really? Just silence.
Absolute silence. It's an extension of that friction strategy we talked about.
So ignoring it isn't just sloppy, it's a tactic.
Exactly. They are testing her. They want to see if she really has the stamina to follow through.
Wow. So they force her hand.
They do. Rossmann only reacts when the actual court order, the Mondbescheid, is served.
And on September 4th, they officially object to it.
The Widerspruch. And the wild thing about this objection is that under the German legal system, it requires zero justification.
Wait, they don't even have to give a reason?
Nope. The corporation just checks a box that says, I object to this claim in its entirety.
And that completely blocks the simplified payment process.
It brings it to a screeching halt.
That seems like a massive strategic advantage for the corporation.
It is. They just throw a legal wrench into the gears without having to explain themselves. Look at it in isolation. It's financial madness.
Totally.
But on a systemic level, it's an insurance policy against setting a precedent.
I see.
Corporate legal departments are terrified of the word getting out.
Yeah.
They don't want people thinking, hey, if you write a mean letter, they pay up immediately.
So they play the odds.
Exactly.
Yeah.
They calculate that out of 100 court orders, maybe 95 customers will just fold as soon as the objection is filed.
Because the objection has a really serious consequence, right?
A dramatic one. It forces the creditor, our consumer, to move the case into a full-blown regular lawsuit.
Oh, wow. So now she has to file a formal statement of claim.
The Klageschrift. She has to submit evidence, make motions, argue the law.
And this is exactly where 99% of regular people give up.
Of course. Nobody wants to hire an expensive lawyer over $50.
And most people can't write a legally watertight lawsuit by themselves.
That's usually the threshold where everyday justice just crumbles.
Not this time.
No, not in this case.
Because she has LegalTech on her side. So on October 19th, she submits her statement of claim.
And you read this document, didn't you?
I did, and it is a 5-page masterpiece of legal architecture.
It really is.
It's not some angry rant from an annoyed customer. It is cold, flawless, and built on 2 massive pillars of logic.
Let's break those pillars down, because they really show how AI-assisted thinking structures complex law.
Totally. The approach is brilliant because it combines legal expertise with this almost algorithmic analysis of the opponent's own marketing.
So the first pillar of her lawsuit relies on statutory law, specifically Section 477 of the German Civil Code.
The BGB.
All right. This section is about the reversal of the burden of proof in consumer sales.
Which is a huge deal in consumer protection. Can you explain how that actually works in practice?
Sure. Normally in civil law, if you claim something, you have to prove it.
Like if I say the product was broken when I bought it, I have to prove it was broken then.
Exactly. But the law recognizes that consumers really can't do that with complex products or food.
I mean, how could the plaintiff possibly prove what went wrong at the baby food factory?
She can't. So Section 477 flips the script.
Okay.
It says that if a defect appears within a year after the purchase, the law just automatically presumes the item was already defective when it was handed over.
Wow, that's powerful.
It is. So she doesn't actually have to prove that the powder was objectively spoiled or why it smelled bad.
She just has to show that she noticed the smell right after buying it.
Yep. And instantly, the burden of proof jumps over to Rossmann.
So the corporation would have to prove that the baby food was in perfect condition at the exact moment she bought it.
Which is a remarkably high hurdle for the drugstore.
But she doesn't just rely on the civil code. Her second pillar is even more elegant.
Because she uses the corporation's own weapons against them.
Exactly. She cites Rossmann's own advertised return guarantee.
The company aggressively advertises on their website, in bold print that customers can easily return items.
It literally says, and I quote, "Are you nevertheless dissatisfied with one of our articles? No problem. You bring the article back to us, we refund the purchase price."
And this is where the power of structured text analysis shines. Large language models are incredibly good at this.
Because a system can scan a company's marketing copy and cross-reference it with the legal facts.
Right. Her argument is devastatingly simple.
Rossmann's own advertising doesn't require an objective, provable legal defect for a return.
No, they tie the guarantee to pure subjective dissatisfaction.
And the consumer was dissatisfied with the smell, so based on the corporation's own rules, they have to refund the money.
It is logically inescapable.
So this razor-sharp 5-page lawsuit lands on the desks of the legal department in Bergwittel.
And now the corporation has to show its cards.
They have to write a formal defense, the Klagerwuterum.
And a human corporate lawyer takes this on.
And what this human lawyer submits to the court is honestly why this case is so fascinating.
It's mind-boggling.
The document is so full of contradictions, you honestly have to rub your eyes when reading it.
We talk a lot in the tech world about AI models hallucinating, right?
Oh, all the time. Inventing facts, losing context.
But this case proves that humans hallucinate just as much, especially when they are stressed or unorganized.
This aspect of the case files is just unbelievable. The lawyer completely trips over his own arguments.
Because in civil litigation, consistency is the bare minimum. You cannot state a fact in one brief and completely deny it in the next.
Let's lay out exactly what he did. In his very first brief, dated November 25th, the Rossmann lawyer talks about the incident in the store.
Okay.
He writes, literally, "The plaintiff demanded a refund due to the alleged defect."
A very clear, unambiguous sentence.
Right. She was at the register. She wanted her money back. Logical.
But then let's fast forward just a couple of weeks.
December 11th, the exact same lawyer submits another brief.
And suddenly he tries to argue that the plaintiff doesn't even have the right to sue.
And he writes, and again I'm quoting exactly, "For the sake of good order, it should be pointed out again that at no point was a payout of the purchase price demanded."
That is a catastrophic error.
He is denying a fact that he himself introduced to the court just weeks earlier.
It totally destroys the logic of his defense, and it completely shreds his credibility with the judge.
To put this in computer science terms, it's like a large language model suffering from an overflowing context window.
Exactly. Like the model got an instruction in the prompt, but 20 paragraphs later, it completely forgets it and argues the exact opposite.
Except here, it wasn't an algorithm failing. It was a highly paid human lawyer.
And the plaintiff, using her structured tools, exposed this flaw instantly.
Because an AI doesn't forget its own prompt unless you tell it to.
It cross-referenced the December brief with the November brief in milliseconds and flagged the logical contradiction in bright red.
This contrast between machine precision and human carelessness is the core of the legal tech revolution.
Because that human lawyer's probably juggling hundreds of these petty claims.
He's just copy-pasting text blocks, losing track, and clearly not reading his own files carefully.
While the plaintiff is using a system that saves every single keystroke, indexes it, and checks for logical consistency.
But the Rossmann lawyer didn't just make formal errors, he also started making arguments that were, quite frankly, morally questionable.
Yeah, the corporate defense went from being illogical to being straight up offensive.
In one of the briefs, the lawyer suddenly accuses the consumer of abusing the $2.49 return promise.
And then he plays a card that is just absurd.
The food waste argument.
Right. A billion-euro retail giant accuses a concerned mother of contributing to food waste.
Because she didn't want to feed what she thought was rancid porridge to her baby.
All to avoid paying back €2.49.
It's a completely toxic line of reasoning.
It is. It's a desperate attempt to reframe a legal problem into a moral failing on her part.
Because they realize they're losing on the legal merits.
Exactly. They try to cast her in a bad light, implying she has malicious motives.
It's almost like a corporate, watered-down version of victim blaming.
It really demonstrates how legal expertise is often wielded just as an intimidation tactic.
They hope the consumer will just feel ashamed because a fancy law firm has officially accused her of abuse. But she doesn't let it shake her.
Not at all. She dismantles these pseudo-arguments completely emotionlessly in her reply.
So at this point, the corporate side realizes their legal and moral smokescreens aren't working on the judge.
The judge at the Amtsgericht Bergwedel was already hinting that she might side with the plaintiff regarding the marketing guarantee.
So Rossmann panics, and they pull out their ultimate weapon.
Scientific authority.
They submit an official laboratory report to the court.
This is such a classic litigation maneuver. It's often called document dumping.
You just bury the other side in paperwork.
Especially when dealing with laypeople. You hit them with highly official documents full of jargon, stamps, file numbers, government letterheads.
The goal is just sheer intimidation by authority.
Exactly.
So Rossmann submits a report from the CVUA, the Regional Health and Veterinary Office.
Which is, ironically, the exact same office the plaintiff contacted on the day of the incident.
Right, and this report details the microbiological and sensory testing of the baby food.
And the department's conclusion is that there were no abnormalities.
It states the product was fully marketable.
So Rossmann proudly presents this government document to the court as absolute, undeniable proof.
The message is basically, look, the state lab says everything is perfect. The customer is either imagining the smell or she's lying.
And honestly, this is where 99 out of 100 consumers would throw in the towel.
When a government agency says in black and white that the product is fine,
most people would just think, okay, I have no chance. My personal experience means nothing against this official paper.
But once again, this highlights the sheer superiority of a structured, unemotional analysis powered by AI.
Because the plaintiff doesn't just skim the document. She absolutely dissects it.
She applies information extraction principles.
And she finds two fatal logical flaws in this report.
Flaws that the arrogant corporate lawyer completely missed.
So first of all, she asks, which package did the lab actually test?
Because it wasn't hers.
Exactly. If you actually read the methodology of the report, you find out the health inspector went to the store the day after the incident.
August 16th.
Right. And they just grabbed a completely different unopened package off the shelf to test.
While the open package that started this whole dispute was sitting at the plaintiff's house.
Scientifically, that is madness.
It's like if I want to prove my car's brakes are defective and the mechanic inspects my neighbor's identical car and says, well, these brakes work perfectly fine.
It proves absolutely nothing about your specific car.
The lab proved that one random package from the batch was fine.
But it says literally nothing about the actual condition of the plaintiff's package.
It's a textbook logical fallacy.
But it gets even better. She delivers an absolute knockout blow in her rebuttal.
Oh, this is the best part.
She quotes the very last sentence of the exact lab report that Rossmann submitted as their ultimate proof.
Do you know what that sentence says, verbatim?
Let me guess.
The cause of the complaint cannot be determined from this.
Oh.
Their own lab, their own scientific authority, states in its conclusion that their testing cannot resolve the customer's complaint.
How on earth does a corporate lawyer submit a document as evidence when the final sentence literally says, we can't prove anything here?
It just proves how unstructured these legal departments can be.
The lawyer probably just glanced at the cover page, saw the word marketable, and blindly forwarded it to the court.
He didn't bother to check the logical chain of the report.
Meanwhile, the plaintiff, using tools like ChatGPT, parsed the document logically.
The system actively searches for contradictions and methodological limitations.
And it found them. She turned the defendant's own evidence into her weapon.
She dismantled the government authority with basic logic.
I can just imagine the mood in the Rossmann legal department when they read her brief.
It must have been pure panic.
They realized their legal arguments were contradictory, their moral high ground was gone, and their scientific proof had just been destroyed by grade school logic.
Plus, the court is hinting more and more strongly that the marketing guarantee is binding.
So when a corporation realizes they are going to lose hard in court, what do?
They panic. And that panic usually leads to a sudden settlement offer.
We're in December 2025 at this point, months after the initial incident.
And right before Christmas, a new letter from Rossmann arrives.
The aggressive tone is completely gone.
The lawyer suddenly says they're willing to pay.
They offer the $2.49 for the baby food, plus the expenses, which are now at €7.60.
So €10.09 in total.
But, and this is so typical for corporate arrogance, they don't frame it as an admission of fault.
No, they say they're doing it purely out of goodwill without acknowledging any legal obligation.
Basically acting like they are graciously giving her charity.
And they attach a condition to this charity that really shows their true colors.
The condition is basically a gag order.
For $10.
Rossmann officially demands that once she gets the money, she must consider the matter closed and take no further action.
And then comes the kicker. They state she must not make any further negative statements about the defendant and the product. You really have to let that sink in.
A retail giant with billions in revenue operating across Europe is so terrified of one single consumer.
That they try to buy her silence and sign away her right to free speech over a package of baby food.
For 10 euros and 9 cents.
They weren't trying to find the truth in court. They were trying to buy a non-aggression pact.
It's the moment the mask of customer friendliness just completely slips off.
It reveals how they actually handle conflicts.
They were abusing the legal system. Instead of admitting a simple customer service mistake, they use gag clauses to contain the PR damage.
Morally, it's just bankrupt. They're exploiting their power to silence legitimate criticism.
But they miscalculated again. She refuses to play along.
She turns down the settlement. She will not be silenced for 10 euros.
She insists on a formal judicial ruling. She wants it on the record who was right.
That is an incredibly brave and strategic move.
It forces the court to actually make a decision on the merits.
And it denies Rossmann the chance to just bury the case quietly.
And her persistence pays off big time.
On February 4th, 2026, the Amtsgericht Burgwedel issues its ruling.
In a simplified written procedure.
And it is a devastating, absolute victory for the consumer.
The court rules 100% in her favor.
Rossmann has to refund the purchase price, cover all her expenses, and crucially, pay the entire cost of the legal dispute.
We are talking court fees, dunning fees, and whatever massive internal costs the Rossmann legal team racked up.
2.49 euros ballooned into hundreds, maybe thousands of euros in wasted resources.
The judge's reasoning is the best part, though.
It really is. The judge completely ignores the whole debate about the lab report, the health department, and whether the porridge was objectively rancid.
She just cuts right through the noise and leans entirely on the plaintiff's argument about the marketing campaign.
The ruling is essentially a massive slap in the face to Rossmann's marketing and legal teams.
The judge dryly points out that the company publicly advertised a return guarantee based on dissatisfaction.
And that wording is legally binding.
It is entirely irrelevant whether there was a legal defect under the civil code.
The customer was dissatisfied, she returned the product, so the guarantee applies.
The fact that she didn't explicitly say the word dissatisfaction at the register, but instead complained about a rancid smell, doesn't change anything.
I mean, how much more dissatisfied can you be than suspecting your baby food is spoiled?
Rossmann is simply bound by its own grandiose advertising promises.
It's a legal triumph for structured analysis.
She used the defendant's own system against them.
She proved that with precise logic, persistence, and the right tech tools, a layperson can fight on equal footing in court.
The corporation tripped over its own hubris and contradictory arguments.
It's just a total liberation, and this case made waves, not just in legal circles.
The blog post that documented all of this, with Professor Beel's help, includes something that just perfectly tops off this absurd story.
Oh, we definitely need to talk about the cartoon.
Yes, the visual, satirical summary of the case. It's a wonderful example of making complex legal matters accessible to the public.
The cartoon is pure genius. And the best part, it was almost certainly created using generative AI, probably something like DALL-E through ChatGPT.
So you have this image of a classic drugstore setting. The typical lighting, the shelves.
But the big sign above the store doesn't say Rossmann. It says Esselmann in huge letters, which translates to Donkey Man.
And in front of the register, there's this completely desperate father.
He's holding a baby who, and the AI got really graphic here, is vomiting this massive arc of neon green sludge.
And there's a bowl on the counter emitting thick, glowing green smoke.
The cashier is just standing there with her arms crossed, looking completely bored, saying, "Return denied, it's already opened."
And my favorite part is in the background. It's like an Easter egg.
Yeah, you see an AI robot wearing a lawyer's suit quietly sorting through legal arguments.
It is the absolute perfect visual satire of how absurd this corporate behavior was.
Now, we do need to make a quick legal disclaimer here as experts.
Right, of course. This cartoon is pure satire. It is not making a factual claim.
Neither the blog post nor the court ruling stated as an objective fact that this specific baby food was actually spoiled, rancid, or toxic.
The court left that factual question completely open because the return guarantee made it legally irrelevant.
The cartoon just exaggerates the coldness of the corporate machine and the feeling of powerlessness consumers have when faced with bureaucracy.
It's an artistic commentary on the power imbalance.
But it captures the consumer sentiment perfectly. And it shows that the plaintiff didn't just win the legal battle, she won the narrative battle too.
So let's wrap this all up. What does this wild story mean for you listening right now while you commute or do the dishes?
Should we all just start filing court orders for every moldy yogurt or wrong USB cable we get?
No, absolutely not. The legal system would collapse, and it's just not socially productive to sue over every tiny annoyance.
That's definitely not the takeaway here.
The real message is about empowerment. This case is a massive victory for practical consumer protection in Europe.
It proves that you don't have to just accept it when corporations try to brush you off with artificial barriers, hotline queues, or legal jargon.
Exactly. If you have a legitimate issue, like an incorrect bill, an ignored complaint, or just unfair treatment, document it.
Take photos, get witnesses, write down the times.
Check your rights. Use AI tools to help you understand them if you need to.
Pay strict attention to deadlines. And above all, be consistent.
If you're in the right, do not fold just because you get a letter with a fancy corporate stamp on it.
Especially if that letter is full of contradictions.
But we also have to remember AI models like ChatGPT do not replace human lawyers. And they certainly don't replace judges.
They can't represent you in a courtroom.
But they act as an intellectual exoskeleton. They help you structure huge amounts of text.
They can help you fill out complex court forms flawlessly.
They analyze the opponent's briefs and spot logical errors like our hallucinating corporate lawyer in seconds.
They demystify complicated official reports by checking the chain of causality.
They drastically lower the barrier to the justice system and level the playing field between David and Goliath.
And that is exactly why we are so fascinated by this case.
We aren't judging whether that semolina porridge was actually good or bad.
But we can absolutely admire the brilliant strategy, the structured approach, and the sheer relentless persistence of the plaintiff and Professor Beel's department.
They prove that the rule of law works if you know how to operate its mechanics.
They completely disarmed a corporation that burned hundreds of euros just to avoid refunding 249 using nothing but pure logic.
It is a masterclass in the value of consistency and structured thinking in legal disputes.
And that brings me to a final thought I want to leave you with today. Just let this sink in.
Okay.
If a single methodical consumer can force a billion-euro retail giant to its knees over a ridiculous €2.49 just because she refused to be intimidated and actually held them to their own marketing fine print.
What other unwinnable battles are out there?
Exactly. What other seemingly hopeless daily conflicts with government agencies, insurance companies, internet providers are suddenly completely winnable if we just stop acting like beggars and start systematically using our rights?
Something to think about.
Definitely think about it. Until next time.